So we're going to begin our study of employment law by focusing first on the employment relationship. What is that contractual, societal relationship that is at the core of employment law? Now, we know that the employment relationship has experienced numerous changes over the last 100 years, and most of those changes are related to greater government regulation. The government has proved itself more and more willing to intrude in the affairs, the relationship between the employer and the employee. And in large part, we have decided as a society that it is a matter of public concern that employment relationships are not just about the employee and the employer, but it is a matter of importance to the public as a whole. And of course, the problem with government regulation is that we have to draw a line somewhere between the notion of freedom of contract, and we'll be talking a lot about freedom of contract in this course, which is to say two parties should be free to contract to whatever they want to contract to, and the idea of regulation of employment, that because of the power disparity between employers and employees, we have to regulate employment. So this question of employment law is made even more complicated because in our system, we have workers who may or may not be employees. So one of the things we're going to be touching on in the next lecture is how do I, as an employer, know who is an employee and who is an independent contractor? Because all of the law we're going to talk about in here, all the government regulation that we're going to talk about, is for the most part only going to be employed against employees. So in this lecture, we're going to look at the evolving nature of the employment relationship. How has the employment relationship changed from what it was to what it is today in the 21st century? So we start with this basic idea that an employer can make any employment decision that it wants to, as long as that decision is not based on a wrongful reason. So any employment decision, hiring, firing, promotion, demotion, change in schedule, change in location, any employment decision that it wants, as long as it's not based on wrongful grounds. And when I say wrongful, that of course includes illegal grounds. We'll be talking a lot about things that are illegal, but also things that may not be illegal, but are against public policy, the things that we don't want employers to do. But this is the idea that underlies all of employment law and the employment relationship, that an employer can make any employment decision that it wants as long as it's not doing it based on wrongful grounds. Now, the institution of employment is actually a fairly recent innovation. When we think of employment, this is actually pretty recently, when I'm talking about maybe 100 years or so, the idea of the employment relationship. You know, historically, laborers and owners, workers and the owners of capital had a relationship that went beyond just employment, that they oftentimes were based on the apprentice idea that we would bring someone into the company, you know, say you're a shoemaker, and you would go out and you would apprentice someone to learn how to make shoes, and there would be a close relationship between the two, and the rules of employment were based not on contract, but on the existence of this relationship. And these historic rules evolved into what we now call the master-servant relationship. So these rules, which really date from medieval Europe, this master-servant relationship, the rules that govern the relationship between a master and its servant, are going to evolve into fundamental employment law. And so in this class, we may be talking about a statute that was passed last year as employment law, or we may be talking about a rule that dates from the 1300s, and that's employment law too. So the master-servant relationship lives on in much of what we talk about when we talk about employment law. Now, under the common law, and we'll touch more on what the common law is, but what this says is that historically, the relationship between the master and servant was based on the idea that the master had a duty to give legal orders, to only give legal orders, and to treat his servant well. So the master has that duty. And the servant had a relationship as well, a duty as well. The servant had a duty to obey all the legal orders that the master would give. And so this set out the broad parameters of the relationship. The master's going to give only legal orders and to treat his servant well, in large part by providing him with a safe place to work. But the servant has a duty as well. The servant has to obey those legal orders. And the servant has a duty of loyalty to the employer. And these ideas continue to be useful in employment law today. This master-servant relationship also led to a concept that we call respondeat superior. And that's a Latin phrase that says, let the master answer. And what it means is that because this relationship exists, we may be able to transfer the wrongs that the servant commits to the master. Where this comes up is what we now know as vicarious liability. So say you have say you own a trucking company and you hire drivers and you're very concerned about your drivers. You want to hire the best, safest drivers you can. And so you do thorough background checks of your drivers and you do drug tests and alcohol tests. And then once you hire them, you send them away for training, and they're training for 6 weeks. And then you bring them in and then you make them periodically retrain. And you as an employer do everything you can to ensure that your drivers are as safe as possible. And yet one day, one of your drivers goes out at lunch and has a few drinks and becomes intoxicated. And then he gets in the truck belonging to you, and he goes and crashes it into someone. And that person is hurt, injured. That person is going to be able to sue the driver, right? The driver's the one who did the wrong thing, got drunk and drove and got into a crash. But the injured party, the victim, is also going to be able to sue the owner of the company itself. And why is that? Well, we take it for granted now, but it's based on this old relationship between master and servant, and that it said that if a servant was doing the master's business, then it was just as if the master was there himself. And so we have incorporated this into our tort law that says if an employee causes harm to another, if that harm was in the furtherance of the employer's business, the employer then is going to be liable for the harm. We'll be talking a lot about respondeat superior when we get to classification, but it's an area that you should become familiar with because we'll be addressing it a lot in here.